Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. We are here for oral argument in cause number CV180049, Mountainside versus City of Flagstaff. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the brief, we've conferenced the case, and are familiar with your arguments. Given that, counsel, you may proceed.
Good morning. May it please the court. Jeffrey Gross, Barry Riddell, LLC, here on behalf of Appellant Mountainside, MAR, LLC. There are two issues that I'd like to address this morning, which I think are really the substantive issues in the case. One is whether the notice of claim contained a specific amount for which the claim can be settled, and the other is whether the filing of the lawsuit was timely, which depends on when the claim accrued. So I'd like to first address the contents of the notice of claim. Basically, the city's argument is that the notice of claim didn't contain the words or the equivalent, "We will settle for $1 million, the amount of the development fee, or we will release the city for payment of the $1 million fee." That issue was not decided by the trial court. The trial court decided in this case entirely on the grounds that it was the complaint and the notice of claim were filed untimely, didn't get to the adequacy of the notice of the claim itself, particularly with regard to the interest issue. That issue has not been developed on the record. The city claims that it could not tell from the notice of claim what the amount of interest was.
Can we start with a more fundamental question about this? Okay, so your clients are developers. They were given a bill that was $1,224,900, whatever. It's about a little over $1 million.
Right.
And they said, we will pay these taxes in protest, and then filed their notice of claim that said they wanted the entire amount back.
Yes.
So when we look at the paragraph that precedes the conclusory paragraph, actually it's 3 paragraphs up, it says, Mountainside recognizes the city may in the future adopt development fees properly calculated under the requirements of certain section of statute 9363 sub 05, and that it may be required to lawfully assess water and wastewater fees in connection with this development when those fees have been determined in accordance with Arizona law. So let's look at that right there. What that says to me, and I may be completely off the mark, it's happened before, it will likely happen again, but let's make sure that I understand what you're saying. What you're saying is they acknowledge that they need to pay development fees, and when we look at the notice of claim up in the beginning part, it says they were aware they were going to have to pay development fees, but these were bigger than the development fees paid in Scottsdale. So your client acknowledges some development fee was owing. Is that correct?
No.
Okay, then let's take up that point.
My client acknowledged that if the city wanted to go through the process in 9-463.05 of enacting the water and sewer development fees, then the city can do that. But to date, they hadn't done that.
Can the city do that retroactively?
No.
So you're saying they would be prohibited by saying anyone who wants a connection or who has been connected in the last year has to pay this amount? Would they be precluded from doing that?
Yes.
And what would be the rationale for?
Because the city has to go through a certain process, including doing infrastructure plans, doing analyses, all of these things to determine what going forward they need to do to impose these development impact fees. There's no of
this particular piece of property that
Yes.
they're doing the analysis on, so they can't do that retroactively and figure out.
No, because development impact fees, the 9-463.05 provides a very detailed and in some respects cumbersome process for the city to go through to adopt development impact fees, regardless of what property that they're applying to. So they have to do infrastructure plans for the city as a whole. They have to go through a process for determining what what future needs the city as a whole is going to require. And then only after studies, after publication, after going through a hearing process, then they can adopt development impact fees that apply to the city as a whole. And they can adopt different areas where the impact fees will apply. But it's not a property by property type of analysis or adoption. It is a citywide adoption. And as far as I know, there's nothing in the statute that says we can make this retroactive to folks who have already hooked up to our water and sewer system.
So your client's position would be, even though we've been connected to the services, to the water services, we don't have to pay any type of fee because you just didn't go through the process that you needed to go through before doing it.
Yes.
So if I could backtrack, sorry, one step before that, people have all kinds of reasons for settling for some amount less than the overall amount. People come in and say, well, I realize the city may have some argument. I don't want to go through the cost of litigation. I will settle for $3. I will settle for, isn't that the point? You've just said this is the overall amount you've charged. And isn't that different than saying, we will settle, we understand there may be some arguments out there somewhere, we will settle for this amount? And that doesn't seem to be what's in the notice of claim. It's just this is the overall amount that you charge that you should not have charged.
I think when you read the notice of claim as a whole, as this court, as the Arizona Supreme Court has said, must be done, and in light of the purpose of the statute, when the notice of claim says our damages are $1 million, let's just call it $1 million. We've paid $1 million. We shouldn't have paid $1 million. The developer is entitled to a full refund, and our claim is for $1 million. If you have 60 days to accept or deny the claim. If you deny it, then we'll pursue our legal remedy, which implicitly means if you do pay the claim, we will go away. We will forego litigation. Sure, there is an option to ask for a lesser amount in order to avoid litigation. That doesn't mean that a claimant in a notice of claim necessarily has to make a demand for something less. In this case, when you read the notice of claim as a whole,
wait a minute. That's the whole purpose, is to tell the other side or tell the governmental agency, this is what I'm willing to settle for.
Sure.
You didn't say that in this letter.
In context, what the letter says is the developer is entitled to a refund of the amount that was paid.
Wouldn't and the amount really was paid for you to say, and we're not going to accept anything less?
No, but that's what the notice of claim said, is the developer is entitled to a refund, and our claim is for the full amount.
Well, that's your demand, but it doesn't say anywhere in this letter that you're willing to settle for any less than the full demand.
And there's nothing in the statute that says we have to say we are willing to settle for something less than the full demand. The full demand was our offer, was the amount that we were willing to accept to forego litigation, and that's the purpose of the notice of claim. And it's almost exactly like the notice of claim that the court considered in the Coughlin case, which is an unpublished decision, but it was published in 2015, and it can be cited for its persuasive value. And
I thought it said that notice of claim must contain a specific amount for which and I'm quoting now, there's a specific amount for which a claim can be settled and the facts supporting that amount. So you're saying all or nothing?
Yeah, I'm saying that notice of claim doesn't have to discount
but if you had said all or nothing, that's where you're either taking it or leaving it.
Well,
can I ask just a hypothetical, a tort case? Mm-hmm. Someone is injured and they say, I have $500,000 of hospital bills. My claim against the state is for $500,000 in hospital bills. Is that so? That's enough. It just says I've incurred $500,000. Would that put the government on notice of the amount they would take to settle the case?
If the notice of claim also said, like ours did, that the claimant is entitled to a refund of the amount or payment of the amount of medical expenses incurred, yes.
But isn't that what a complaint, usually I'm entitled to $500,000 in hospital bills that I paid because of an injury. We would find that that's adequate to put the government on notice and that's all I will settle for is $500,000. I won't settle for a penny less.
Yeah, yes. In context, when you explain, here's what happened, here's the medical bills we've incurred, our claim is for $500,000 in medical bills. Yes, and that's exactly what the notice of claim said in the Coughlin case. The notice of claim said a sum certain demand is being made against the state of Arizona for $4 million. And this court said that that notice is clear that all four claimants in the wrongful death action were offering to settle the single claim against the state for $4 million. And again, you go back to what the court said in Yahweh, what the court said in various cases, Jones, Yawlin, about what an offer is. An offer is a willingness to enter into a bargain so that the recipient would know that an assent to it would resolve the matter. And when the notice of claim told the city that the amount of the payment was $1 million, that the developer was entitled to a refund of $1 million, that the let me get the exact lange.
Well, while you're looking that up, I really want to go
$4 million.
back to your letter, if I could. In your letter, at the bottom of 3, it's on page 5. You say it was all or nothing, yet in this letter you say that the city may in the future adopt development fees properly calculated under the statute, and that it may be required, it being Mountainside, may be required to pay lawfully assessed water and wastewater fees in connection with this development. So I don't see that as an all or nothing. You're recognizing that you're going to have to pay something. It may be in the future, but you recognize you have to be something, so how are they supposed to know what that something would be?
I think those are two different things. One is we have paid the city $1 million. The other is, and I don't know what the person who wrote this letter was thinking, but the other is, okay, in the future, we may be obligated to pay you some fees. But at this time, you didn't have the authority to charge us $1 million, so we're entitled to a refund of that.
Okay, let me ask a quick question. You've said $1 million. You've said in your letter, notice of claim, not you, but whoever wrote it, has said, $1 million, we paid you $1 million. But they're also saying, once you get all of this stuff done and get in compliance with the statute, you can retroactively charge us, which is why we asked about that retroactive portion. In the future, you may charge us for development fees when they've been determined in accordance with state law. So there are a couple of things here. One, that doesn't sound like $1 million is what your client or whoever's client this was at the time expected to pay. Number two, it sounds like Mountainside is acknowledging that they owe some development fee. So wouldn't the sum certain be whatever they believe that fee should be, because they knew it was too much, so they had to know what was about right? That's how much we'll settle for. Wouldn't that be?
No, because there's no assurance that in the future the city is going to adopt a development fee pursuant to the statute. What this letter is saying that, okay, sometime in the future, you may adopt this development impact fee, and maybe according to the letter, it can be applied to this development.
But wouldn't that be a way to resolve the dispute with the city, to say, whatever you do going forward, everybody's going to agree that the appropriate amount, that we're not going to pursue anything against Mountainside if you'll pay $600,000 or $800,000. Our dispute is what's the overall amount we should be paying, and we think it's clearly less than 1.2. And if you're willing to pay this, then do whatever you want, and we'll all just move on. Wouldn't that suggest that there's an amount less than 1.2 or whatever the amount in the?
I suppose that could have been an option, But there was no, at the time, the developer had paid $1 million. That $1 million was alleged to have been invalidly collected. So whether the city may or may not adopt future development impact fees that may or may not be applied to this property at this point in time, at this slice of time, as of November 7, 2016, all we know is that the developer overpaid $1,024,991. We don't know if there's ever going to be a development fee that the city is going to adopt. We don't know if the city adopts a development fee that's going to be applicable to this particular property. So we don't know if there is going to be a time when there's going to be any offset. Now, that may happen in the future, and in the future, if that fee is validly adopted, well, then maybe the developer has to pay it. But that's something that's conditioned on future events happening that we don't know in November of 2016 that's going to happen or not. So it's not $1,024,991 less something else. It's $1,024,991 with the understanding that at some point in the future, something may happen to obligate the developer to pay something. But we don't know what that is. We don't know if it's going to happen.
What if the scenario had been Mountainside refuses to pay anything because they say it's too, they haven't gone through the process, so you can't charge anything? Could they file some sort of mandamus action to say, you have to connect us for free because you haven't gone through the process, so you have to turn on the water for us and connect all our, do whatever it is that they've received for that fee? Are you saying your client could have done that? Is it entitled to because the city hasn't gone through that?
Yes.
And I'm just wondering, so there's no unwrapping the entire transaction. Look, you overcharged us. We acknowledge you're not going to connect for free, but you're saying you could have just said, you've got to just let us connect and then you go and figure it out later? Is that?
Yeah, I suppose Mountainside could have said, we're not going to pay you anything, and we need you to collect. We need to connect because this is a property right we have, and could have sued for specific performance or mandamus or declaratory relief, which in that case the no notice of claim provision would have applied. But and then there would have been no settlement requirement at all because there would have been no money damages unless Mountainside decided to make a claim for delay damages.
Your client received a benefit by the payment of the $1 million blah, 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 which is being hooked up to the city's utilities, correct? And your client doesn't believe that's of any value, so it's all or nothing. They're going to win at the end of litigation and get their $1 million back, or they're going to lose and get nothing back.
Well, that goes to the merits, I suppose, of what they're entitled to. It doesn't go to the notice of claim because we're not entitled to anticipate a city defense, which is you've benefited, therefore you have to pay us something.
I'm just wondering, when we talk about what your client was willing to settle for, all or nothing, and that's it. And that's your position. My
position is the notice of claim has to contain a sum certain for which we would accept, we would settle for. It's an offer. It's a willingness to enter into a bargain. That willingness can be to our client's discretion, just like putting facts in a notice of claim is at the claimant's discretion. You know, the claimant has the discretion to put in what they're willing to accept. In this case, when you read the notice of claim in context, Mountainside was willing to accept a refund of the fee, not obligated to take a discount or anything else.
Plus interest.
Plus interest.
So when we talk about plus interest, that is not a sum certain. How do you address that?
Well, first of all, it is a sum certain because we gave the city the method for calculating that interest, which is go look at your books and determine how much you actually earned on this million, blah, blah, blah. We gave them that under the A minor case, which we've both cited, a sum certain, I'm sorry, not a sum certain, a method of calculating an amount is adequate to be for purposes of interest. I would add that the record is not fully developed on that because the city claims, well, we couldn't have figured that out because all it does is go into a big pool. We put it in different investments, and it's very difficult for us to figure out what interest we're earning on any specific amount. There's nothing in the record to support that. They made that allegation in their motion to the response or their reply to the motion to dismiss, and in their answering brief here. We don't know that that's true. We don't know how difficult it would be for them to figure that out. That's something that the trial court never considered, and that's something that there is no evidence on the record. And if there's anything to be sent down, if the court finds that we didn't provide a method for calculating, which is go look at your own books and you guys figure it out because you know what your finances are, then that's something that should be considered by the trial court in the first place. Thank you.
Thank you.
Good morning. May it please the court. My name is Kevin Finzel. I'm the Deputy City Attorney for the City of Flagstaff. I'm here with Sterling Solomon, the City Attorney, and we're obviously here representing the City of Flagstaff in this matter. So I have an outline here, but it sounds like that's just going to go out the window if you've got questions for me, so I'm happy to address any issue you want me to focus on. If I can, there was one question from you, Judge Gattani, and you asked, could Mountainside have sued without the payment before they made that $1 million payment under protest? Could they have filed, and I think you put in the context of a mandamus action, but could they have filed suit? And this goes to the one-year statute of limitations issue, which you didn't discuss with Mr. Gross. But one of the arguments Mountainside is making is, well, we didn't have a cause of action because we didn't pay anything. We didn't have any money damage. We didn't have any monetary damages. So when you look at accrual, you can't look at the assessment, which is the city's argument. You have to look at when we paid something. And I think Mr. Gross's answer to your question was, yeah, we could have sued. We could have sued before we made any sort of payment. And I think you didn't know what he would couch it as, but that's our whole argument on the one-year statute of limitation. It goes to when the claim accrued, and the city's argument is accrued at assessment. And when Mountainside was assessed in August of 2015, it had a cause of action at the latest. Our first argument is they had a cause of action when
their damages don't accrue until they're ready to start and they want to connect. So they could come in and say in the mandamus action, we're now ready to connect. We need some water. We're going to be damaged because we're going to start losing money. That we could start charging people rent. That seems different to me.
Well, and I think we're conflating damages with damaged. So 82101B, which is what Mountainside really focuses on in their briefs, has the word damaged in it. And they try to turn damage into damages. And my argument is, well, that's damage and damages are not the same thing. Damage is harm. Damage is injury. And when you look at where 82101B came from, it came from the legislature trying to codify the discovery rule. And so when you look at the discovery rule doesn't ask, when did you pay something? When did you have monetary damages?
But was the first invoice that was sent out in 2015, is there some penalty? Doesn't it just lapse after 30 days?
It doesn't lapse.
Can you charge them something for not hooking up? What if they have some snafu with their construction and they put things on hold for 2 years?
Right.
They owe the city something?
They wouldn't connect.
Pardon me?
They wouldn't connect without the payment.
Right. But so that to me suggests that there isn't, and you would come up, if they've waited 3 years, some unrelated snafu, you're going to send a different invoice before they can connect, right?
Well, so there are a couple of different questions there. So first of all, we're talking again about when the harm occurred. And I think you're focusing on the payment. And the city's argument is that that's not the harm. The harm here, when you look at the complaint and you go back to it, what Mountainside is arguing is that it was assessed on a legal fee. And to clarify some of the questions earlier, we're talking about capacity fees versus development impact fees. So the city adopted capacity fees, and that's what we're actually assessing. And so when you look at what the complaint's alleging, it's saying those capacity fees are legal. Well, they were assessed those capacity fees in August of 2015. It was at that point their complaint could have been filed at that date, at that time. They had all the facts they needed.
Why would they if you're going to come up with a different amount?
Because there's no guarantee we're going to come up with a different amount. So the capacity fees are, in this case, we're talking about connections. So I think it was 3 2-inch connections and 2 1-inch connections and 161 sewer connections. And that's what we're talking about. And each one of those has a rate attached to it. And that's the only thing that will change. It's the assessment is the same. The capacity fees in both invoices we're talking about here, same. The only thing that changed was the rate, and that's when the city council.
You're saying their damages, Does the claim arise when they find out that the city hasn't gone through the process that they think they need to go through? And they found that out a year before even the first invoice.
Right.
Why isn't their initial claim just untimely? Just if you adopted this procedure 2 years ago, how could they ever file a proper notice of claim? We heard about that. We're developers. We know this is how you do it, but we haven't started construction, and we're not going to file a lawsuit.
Right.
You're saying they would be barred, even though because they knew about it 2 years earlier when you started imposing the fees in this manner?
Right. No, I would say they were barred. The 1 year trigger started to run when they were assessed, when they received that invoice in August 2015. That is when the Mountainside development, and we're talking about the assessment on a development, that's when that Mountainside development received that assessment for $1 million+. And it's that time when the claim triggered. And it's the same holding that was in the home builders case in Surprise.
That claim was for a different amount than the next invoice that went out.
Right. It was a different amount because the rates had changed, but it was for the same assessment. It was the same capacity fees.
So are you arguing that every assessment starts the new statute of limitations of 1 year?
If they're different. So this is one of the arguments Mountainside makes. So again, if you look at the two invoices, the 15 and 16, and you say, what is the invoice for? And you find capacity fees, they're the same. It's the same assessment. Now, the question that you have is more of it comes from the home builders case. And it's like, if there's a different assessment, does that trigger a separate cause of action? The answer to that's yes. And that's what Mountainside is trying to argue, is that 2016 invoice was a separate assessment. Our response is no, it's not. It's the same capacity fees. The only thing that changed was the rate. And the only reason why that changed is because in June, the council changed the rates, which they have the right to do. And that's why when you give a developer an invoice, developers want to know, how long do I have to pay this amount? Well, that invoice says it's valid. It doesn't say it expires. It says it's valid for 30 days. That means that.
So at the end of the 30 days, though, can't each side just kind of walk away? Okay, we didn't connect. Don't you start the process over when you say, okay, now we're ready? How much do we owe?
Well, I don't think that's usually how it happens. But let's say that did happen. Let's say we invoiced in August of 2015, and then Mountainside came in January of 2016. Said, okay, can you send us that invoice? We lost it, or it said it wasn't valid. Can you send us one? It's going to be the same invoice at that time because the council didn't adopt new rates. So, and that's the confusion here, and that's what Mountainside is trying to argue, is that when the rates changed, you had a new assessment, and the response to that is no. All they did was change the rate for the same assessment. So all that information, all that gave to Mountainside is a different claim for damages, but it doesn't mean that's when their cause of action accrued.
I'm hung up on it. You don't really have to pay anything until you're ready to connect. If they just choose for unrelated reasons, we're just not ready to connect. They would have absolutely no recourse to ever challenge the amount of the charge if they wait 2 years for completely unrelated reasons to say, now we're ready to connect. You invoiced us 2 years ago. Now we're ready. It seems like under your argument, they can't challenge in any way the city's process of assessing the fee.
My argument is that they should have challenged 2 years prior when they were assessed. Because again, and I go back to the complaint on this, and I think the complaint's really important because that's their claim. And their claim here is the city assessed illegal capacity fees. They say they're actually development impact fees, you didn't follow the process. Well, that complaint, that claim, that cause of action is based on the assessment of capacity fees. That's the claim. So when they were assessed, that's when their claim accrued.
And could you go to the merits of the adequacy of the notice? Why isn't a complaint that says you can't charge this fee, you didn't go through the process, you've got to return that fee? And why isn't that an all or nothing? You didn't go through the right process. You've charged me $1 million. You've got to return that $1 million.
Are you getting to the offer to settle?
Is that not an offer to settle for $1 million?
No, and I think we make that pretty clear in our answer in brief. And the argument is, I mean, we really focus on the Yahweh case. And I know Mountainside talked about the Coughlin case, but Coughlin was 2 years prior to Yahweh. And I think Yahweh is where this court really clarified what that means to have an offer to settle. And it's that willingness to be bound. Where's the language in there that says, we will be bound, we will settle for this amount? And
well, if you pay them the full amount, they're bound.
Well, and that's an interesting question. If we, let's say, and trying to think of an example, but if a plaintiff, and I think there was one case where there was an accusation of a fishing expedition. So let's say a plaintiff wants to submit a notice of claim, but they really don't know what the city's willing to pay. So they put a claim for $100,000, and the city says, okay, we'll pay that. And so they pay the $100,000, and then the plaintiff says, well, that was just our claim, but that was just one claim. We have 3 other claims, and they weren't in our notice of claim, but they're there, and actually $100,000 isn't going to settle this. If the city walked into this court and said, this language binds the plaintiff, I think there's a good argument that it does not, because all it says is we have a claim.
Well, the only thing that they're asking for, and the only thing that we have anything to deal with, is simply the refund of that fee. So why isn't that, if you refund my money, if you refund the money, we're good.
Well, and that would be the question for Mountainside, is if we would have paid that money, would that have been good?
Well, what else could they have sued for?
They could have, well, the interest claim is there.
Admittedly
Right,
so.
right.
If
So
they-
the interest claim is
Well,
there.
let's say they hadn't claimed any interest. If they just said, you charged us a $1 million connection fee, you didn't go through the right process before charging that, we're entitled to our money back.
And so what's
And so that's not enough to put the city on notice that you can't charge that fee without going through the process. We want all of our money back.
right?
And why wouldn't that be? What else are they asking for? Why wouldn't that be obvious from the complaint?
Well, I think it's not a question of what else would they be asking for. The question is that an offer to settle for a specific amount? And I think you nailed it in your questions earlier, that there is no language. It doesn't have to be settled, but there is no language saying we will accept this sum and this case will go away. It just says we have a claim for this amount. And I think the Scottsdale issue, you're bringing up the paragraph before and the reference to their development in Scottsdale, and I think they say some of that notice of claim about in Scottsdale. The reason why we really came forward here is because we saw your capacity fees, and they're way more than Scottsdale. And then they have the paragraph that says, hey, you may adopt some development impact fees later, and we may have to pay those. So the question is, well, would they have settled for what they paid in Scottsdale? Is that what they were really looking for? Is that the amount? And that's why you have that language in the statute that says you have to provide an offer to settle. You need to tell the city, we will be bound if you pay this amount. And there's just that willingness or that manifestation just is not there.
Hold on, you lost me there, because just because there may have been some discussion earlier, if they had concluded with, and we are only going to settle this if you refund us the full amount of the money, that's
Good to go.
good to go.
Good to go. Because
Okay.
I think at that point they're saying we will settle for that amount. And that's what the Yahweh case is requiring.
So when we read the second to last paragraph of the notice of claim, it says the claim against the city is in the amount of $1 million and change. And we'd like some interest. You have to determine the interest because we don't know what that amount is.
Right.
You don't believe that implicitly that says, if you give me that amount plus interest, we're done here.
I don't think so. I think, after you read the Yahweh case is very clear. It wants to see that language that says, we will be bound if you pay this amount. And in
So
the
it's
Yahweh,
magic language.
I don't think it's magic language, but I think it's more than saying, as in the Yahweh case, we're going to demand this much at trial, or we will demand this much when we file a lawsuit. And here we have a claim. So we have a claim for this amount. But what is the settlement amount? What are you willing to take to walk away? And maybe it would have been that amount. We just don't know. But I think when you read Yahweh, there's putting this burden back on the plaintiff and saying, the statute says you need to provide a settlement offer. You need to provide that offer to settle. And I don't think that language there, that we have a claim.
Isn't there material difference from that line of cases where you're talking about damages that aren't fixed? I mean, we have a clear amount of damages. It's $1 million, yada, yada.
Yeah.
Well,
And they're saying, pay us, refund us this money. Why isn't that just a simple, this is what it's going to take to settle?
I just have to go back to the fact that it just doesn't have that. It just says it's a claim.
But in Yahweh, wasn't it a claim for defamation?
Right,
Where
yeah.
that seems very different than you overcharged me.
I want my money
You
back.
charged a fee that you weren't entitled to charge. It's kind of hard to say defamation. I've been defamed in the amount of $5 million. That seems different than, look, this was a charge that you couldn't charge me for. So you have to return that whole amount. That does seem different to me than the facts of Yahweh. But
Yeah, I think the facts are definitely different, but I think what Yahweh, with the focus there, is just on that when this court came out and said, here's what plaintiffs you have to put in there, and here's the language we're looking for, and it's that willingness to settle language, it's that intent to be bound language, and we just don't think just saying we have a claim for a specific amount, or sorry,
But do
claim
you think
for an
they had
amount
any
gets us there.
claim other than the claim for the $1 million connection fee?
I honestly don't know. That's a question for Mountainside. I mean, a lot of these cases you can get a claim for delay damages. You know, if we don't want to pay them out now because we don't think it's right, we don't think you have the right to charge it. So then that set our development back 6 months. Well, now we have these delay damages. There's all kinds of other damages Mountainside could have claimed. We just don't know what they could have been.
Well, they couldn't have brought that in this suit.
Not at this point. No, we don't think the suit should be brought at all.
Well, I mean, the city didn't not address this letter because they thought there were additional claims coming. There's nothing else in this complaint
Correct.
other than I want my $1 million back
Correct. Yes.
plus interest.
Plus interest. And the interest is obviously a separate issue, and that gets to the specific amount question. And I think they fail on that one too, because Mountainside wants to say, hey, look, we just asked for interest, and we said, city, you know it, go calculate it. And I think there's a problem with that because that's shifting the burden back onto the city. It's saying, city, you calculate the interest for us, and that's not what the statute says. The statute says the burden is on the plaintiff to provide that specific amount. And by Mountainside saying, we want this unspecified amount of interest.
But it's not really unspecified. They are providing a formula.
No, they're not. I would disagree.
But aren't they saying, look, if you have, why can't you read that as the formula is whatever interest you've made on this, if you had a bank account making 2%, we're entitled to whatever you made. If you put it in, if you put it in a non-interest bearing account, then we're entitled to nothing.
Right.
But you and you alone can figure that out based on what's in this complaint. We're not in other ones where it says and we want interest, and the plaintiff doesn't say, well, what rate of interest. Here they've done more than that. They've said, well, it's whatever you've earned on it, and if you haven't earned anything, then fine, we don't get anything. But if you have earned something, then we're entitled to that.
Right, and I think there's a big assumption there, and that's an easy calculation, or that can be calculated at all.
Why could it not be calculated?
Well, I was trying to avoid this, but because it gets into some factual issues, but it's the fact the city takes its money, and when it receives money, it puts it into a fund, and it mingles it with other money, and it invests that money in different areas.
But so why can't you just say our overall investment rate, our overall return for all of the money that we've put in for this last year was 3%? Why isn't it just this percentage of this amount of money presumably earned the same that all of the other city funds earned that were invested somewhere?
And I think that gets you to you could likely get to an estimate of the interest. I think we said that in our brief. Is that could we hire an expert and possibly get to an estimate of the amount of interest that was earned, or maybe it was lost? I mean, these are investments. The city may have lost money on an investment, but could we have gotten to an estimate? Possibly we could have gotten to an estimate. But again, an estimate isn't a sum certain. And that's the requirement here. And I think it's interesting when Mountainside says, look, we gave them a way to calculate it. We said, you know what it is. Well, to me, that's not a method of calculation. In the minor case, they were talking about where two specific methods of calculation were provided, and the court said, you can't give two because they come to different conclusions and we don't have a sum certain. Here they're saying, we're not even really giving you a method. We're not saying 10, they easily could have said, well, we want 10% per annum on this money from date of payment to date of refund. That's the calculation. That's an easy calculation. The city at that point can easily calculate that 10%. But in this case, they just said, city, you know what you earned on it, and to me, that's an assumption. That's assumption saying, city, it's an easy calculation. Go figure it out. And I just don't think that's the answer.
Assumption? I mean, should we send it back to the Superior Court to say, city, do you have all this money just sitting in a bank account earning 2% interest?
Yeah, I would say you don't even need to get to that because, again, I think to me it's more of the shifting the burden argument. And the question. Go ahead.
I'd like to.
Sorry.
Before your time's almost up, so I'd like you to address what we asked the other side, and that is the language where it says we recognize that we may have to pay fees in the future. Can these fees be retroactively applied?
Well, so, and this is why I made the distinction when I first started. We're talking about capacity fees. We have the fees. The fees are going to be charged. They're going to be assessed. That was the email from the city attorney's office. we have capacity fees in the city of Flagstaff for water and wastewater. We don't have development impact fees. So to answer your question, I think if we had them or if we wanted to adopt them, my understanding is once you adopt them, we couldn't make them retroactive in this case. But that's really getting more to the merits and the difference between a development impact fee and a capacity fee. But the city wouldn't retroactively apply anything because we don't have a development impact fees for water and wastewater. We would apply the same fee we have, which is the capacity fee. It's really two separate statutes. So development impact fee is 946305 and capacity is 9-511. We've adopted capacity fees under 9511, and that's Mountainside's argument is, well, we see you did that, but those are really development fees in disguise, and that's our claim, that assessment therefore is illegal.
Why doesn't that go to the merits as opposed to keeping you from ever even reaching the merits of the?
I'm sorry?
I'm not exactly clear why. If you can still impose that fee, you're essentially saying it could be retroactively imposed.
It doesn't have to be retroactively imposed. It's already been imposed. There would be nothing to retroactively impose.
The capacity.
The capacity fees. Yeah. If we turned around and the city.
I think the point that the panel was trying to address is, does that mean that they recognize there's something less to be reached than the million, whatever it is?
Yeah, and I was talking about that earlier with their reference to, we're paying a lot more in Flagstaff than we're paying in Scottsdale. So yeah, that could lead the city to say, well, if that's really your complaint here is that you're getting charged more for these fees in Flagstaff than Scottsdale, maybe they would have accepted the Scottsdale amount.
Are they arguing that you can't impose capacity fees at all?
That's exactly what they're arguing.
That it has to necessarily be a development fee?
Correct. They're saying I'm out of time, but yes, that's their argument, is that the capacity fees are illegal because they're really development impact fees is their argument, and therefore you have to follow that whole section of 946305 and meet all those requirements. And because you didn't, therefore they're illegal, and your assessment is illegal. And I think that's why we focus on assessment.
Thank you. All right, counsel, thank you both for your arguments. We will take this matter under advisement and issue a written opinion or memorandum decision in due course.